Do you solemnly swear that you will conduct this jury to some private and convenient place for their deliberation, there keep them together, and that you will suffer no person in any manner to speak or communicate with them, nor do so yourself, unless by order of the court, except to ask them if they have agreed upon a verdict, and when they have agreed, that you will conduct them into court unless otherwise ordered by the court, so help you God?
Yes.
Now excuse the jury proper. Mr. Busby, you may now proceed with your closing arguments.
Thank you, Your Honor. Just a moment to get set up. Right. So, first of all, I just want to thank you for your time and attention in this matter. I know that we expected a lot of your time, or asked for a lot of your time, and it's a complicated case. We know that you all were paying close attention to what happened here. And, it's not easy, but we're very grateful that you were willing and able to do this, to hear this case. If you recall at the outset, I told you this case was about property rights and the right to live your life and make a living the way that you choose. And, sorry.
And for either counsel, if you'd like to have a lapel microphone, we can do that. It's easier. So make sure you're heard.
I think this should work. Yeah. All right. Sorry, no matter how many times you do this, you still get nervous. So, it's our position that the law you were just read by the judge embodies those concepts. The freedom to live your life, to conduct your work, and to manage your property how you want, free from interference from outside parties. The civil justice system permits parties to bring claims when those rights are interfered with. And you've heard the judge instruct you in great detail on those claims, and I won't belabor those points, but I want to summarize some of the facts that you heard. And the first witness that you heard was Mr. Van Zlum. And the first incident was the August 31st, 2020 incident. And one big core issue in the case is that Mr. Lum concluded that because only one of the pesticides that Mr. Frey was spraying that day was found on Ms. Odum's property, that the pesticide that they did find didn't come from Mr. Frey's plane. Then you heard from Mr. Glenn Miller, our expert witness, a chemist, who explained that he has a lot of experience with this particular pesticide, chloroprophos, and explained that Mr. Lum simply misunderstood and misinterpreted the data that was received from the samples, and that the most likely source of the pesticide found on Ms. Odum's property was Mr. Frey's plane, as it was spraying the same pesticide across in a neighboring property the same day. Now, we're not criticizing Mr. Lum there. His analysis was simply incorrect because he's not a chemist, but it's understandable. I think common sense would lead you in one direction, but this is not an issue for common sense. It's a complicated issue involving chemistry. And Mr. Miller concluded that the fact that they only found one in no way rules out that pesticide found on my client's property came from Mr. Frey's plane. Now, Mr. Weaver admitted to flying over Ms. Odum's property that day, and he illustrated that point by drawing those lines on Exhibit 62A. And all those lines that he drew showing himself looping around, were consistent with Ms. Odum and her daughter, Sarah Baker's testimony of what they saw that day, so the plane circling around their property. Okay, so for the second incident, July 6, 2021, Mr. Lum took 3 samples and nothing was detected. Okay, however, as you heard, Mr. Lum did not take a control sample, nor did he take a sample of the field that was actually sprayed. And Mr. Miller testified that the sampling that was conducted overall was minimal and wasn't adequate. And Exhibit 87 was admitted into the record. And I want to show you a few things from that because think it's important for the case. All right, so this is the FIFRA manual that I discussed with the defendant's expert witness, Mr. Rush. And it basically provides guidelines for doing inspections for incidents like the ones at issue in this case. And it gives very clear instructions on how to do a sample or what to do in particular instances where there's an allegation of overspray. And this diagram clearly illustrates that you take samples of the treated field and you go towards the direction where the allegation of wrongdoing occurred. So it makes no sense just to test the field and to do so in such a minimal way. And based on minimal testing, rule out, as a matter of fact, that spraying occurred that day. And in contradiction to eyewitness testimony, that Mr. Frey's plane was indeed spraying the neighboring field that day. Ms. Odum testified to that, and so did Mr. Rakoff. So, we recognize that the fact that there are negative samples is an issue, but we don't believe the jury should conclude, based on the circumstantial evidence, that it should rule out that a spraying incident occurred on those dates because of those negative samples. So here's another diagram from the FIFRA manual. And this shows how you're supposed to treat incidents of human exposure, which were alleged in this case. And it states at the top there, you take your control samples, and then you take samples in a line at equal intervals, starting from where there's suspected human exposure, and you move towards the treated area. And that gives you sufficient information to determine whether or not there was an actual spraying incident, because you'll know how far from the treated area the alleged spray went. And if you take a control sample, a sample from a field anywhere where there's no allegation of spraying, you know that your background test is going to make sense. You have a neutral test under which you can compare all the others. So for the second incident, you also heard Mr. Weaver testify that he was not spraying that day at all. But Mr. Rakoff testified that he saw Mr. Frey's plane. You heard him testify that the field where the spraying occurred was right across the street from his house. He knows Mr. Frey. He went to the air races with Mr. Frey, the friends. He knows Mr. Frey's plane. So for the third incident, Mr. Frey admitted it was him flying the plane that day. And that's for the August 16th, 2021 incident. And the video in Exhibit 1, which you've seen repeatedly, shows very clearly that Mr. Frey flew low over Salisha's property or close to it. And the complaint by the late George Anderson illustrates that point. Mr. Anderson stated, "It was so low it vibrated our house. It rose back up into the sky about Roberson. There was a smell in the air afterwards. It was flying crazy. Came back over 2 more times, but not as low." Now, when this incident was reported to the Department of Agriculture by my client, Mr. Lum came to the property and he took a single sample. Now, that's entirely inconsistent with what the FIFRA manual requires. There's been some discussion of some other standard, but there's nothing about that in the evidence. There's no other manual or guidebook for spraying, for doing investigations of alleged spraying incidents that's been provided. And Mr. Frey also testified that he told Lynn Weaver to stay away from Salisha's farm before the August 31st and the July 6th incidents. Yet Mr. Frey admitted to flying his plane at least close to Salisha's property. It's entirely inconsistent. If you're going to direct your employee to stay away from somebody's property because of complaints they're making, you're not going to fly your plane that low over their property a month and a half later if you're telling your employees not to do it. Now, I want to talk about the damages issues. Salisha testified she was required to report the incidents to the Nevada Department of Agriculture because of her certification. And as soon as a spray occurs, Salisha testified that her operation grinds to a halt. And she doesn't know for certain what was sprayed at that time. She doesn't know in what amount until the Nevada Department of Agriculture concludes its investigation. And there was some allegations that she could just go for $250, get a sample tested. Okay, well, she can't just do one. How many? How many are adequate? Mr. Miller said 10. How much? 10 times 250, $2,500. Ms. Odum makes $25,000 a year approximately total. So 10% of her income every time this happens, out the window, perhaps. And even if they're positive, what she gets is, the right or the ability to bring a lawsuit. But there's also chain of custody issues involved with samples that are collected outside of Ms. Odum. She collects samples themselves. They can always be attacked on the basis that these positive test results are the result of you collecting the samples yourself. If an independent third party does it, such as the Nevada Department of Agriculture, the chain of custody issue can't be questioned. All right, so for the first incident, it was 44 days from the date of the incident until Mr. Lum issued his report. Now that was, the incident happened in late August, so it was October by the time, theoretically, Ms. Odum could have got things going again, but the season's basically over at that time. Her farmer's market booth is gone, as she testified. She can't just, turn her business on and off like a switch. It's not how farming works. Anybody who's tried to grow anything, knows that. It's not an easy thing to just go out and do. For the second incident, Mr. Lum took 28 days, and that was in July, which is peak growing season. So she shut down for a month during that. And again, she can't just switch it on and off. For the third incident, it was 34 days. So, and you heard Ms. Odum testify that all these days fall within the seasonal window where she can sell her produce to the farmer's market. And you also heard about the psychological impact that has on somebody. Ms. Odum isn't a wealthy person, but she takes pride in what she does. She enjoys it. She gets satisfaction out of it. She grows food for herself and her family. She works for months and months to get prepared to sell her food, and a plane comes along and in an instant it just evaporates. Now, Salisha told her customers that her food was pesticide free, and she wouldn't sell her food to customers that she wouldn't eat herself or feed to her family. And the defendants have tried to use that against her, saying, oh, well, if it just has a little bit of this poison on it, no problem. Well, you heard that the pesticide that was found on her property it's no longer permitted to be used on food crops. Mr. Miller testified that it's a neurotoxin, specifically dangerous for children. If you're an organic farmer and you discovered that this is what was sprayed on your field, the natural reaction is going to be horrified. You're not going to sell this to your customers or eat it yourself. So an important fact is also that Salisha didn't sue the first day after the first incident in August of 2020. She didn't even sue after the second incident in July. She sued after the third incident in August of 2021. And by that time, it was undeniable that this was just going to keep happening to her unless she did something about it. And I want to talk for a minute about the GPS data. Now, the defendants could have preserved the GPS data from their plane to prove where they were flying at all times. And Mr. Weaver testified that they actually do that or did that in some other circumstances. Now, it makes zero sense that they would delete that data when they were flying in or over the area of a person who had made complaints about them to the Nevada Department of Agriculture. They knew that there was a potential for a conflict, and if Mr. Weaver's testimony that he was just ferrying stuff back and forth on the 7th rather than spraying was the case, he could have proved that undeniably by just recording the GPS data. Inexplicably, that didn't happen. So there's also issues with Mr. Frey's records. We showed you exhibits 32 and 35 and exhibit 95, and it's difficult to determine what where they were, what they were doing, because there's conflicting information. There's multiple tickets for single dates. For those tickets, the weather and direction information is not correct. So it's hard for us to tell, just looking at the records, what was happening. And you heard clearly in the law, they're supposed to keep really good records because they're doing something that's really dangerous. I want to talk about the avoidability of this entire conflict. Okay. So Mr. Weaver testified that he could have sprayed the neighboring fields in a manner that would have completely avoided Odum's farm. Now, Mr. Frey testified that doing so would only have cost 30% more. So, for example, a job that costs $9,200, it could have cost an extra around $2,760. But instead, we chose to fly over Salisha's farm and wipe out $10,000 worth of crops in 2020 and $25,000 in 2021. And we're asking you to award $35,000 to compensate Salisha for those losses. And as you heard in the jury instructions, you can also determine whether she's entitled to compensation for things like pain and suffering, annoyance and discomfort, and emotional distress, mental anguish. But we're not going to ask you for a specific amount of these damages. We just ask that you decide a reasonable amount if you're willing or favor based on the evidence and your common sense. What the cost should be to make someone whole after something like this happens to them. Now, I want to talk about knowledge for a sec. Mr. Frey denied that Miss Odum is a farmer. He says she's a gardener. Okay. Well, he knew she was growing an organic garden before August 31st of 2020. And he also stated that he warned Mr. Weaver before that date to stay away, but Mr. Weaver denied that fact. He first heard about Miss Odum after the incident. So, intent. You heard that word several times through the jury instructions. And what's intent? It's just the natural and ordinary consequence of your action. So, in this case, the testimony shows the defendants knew that Odum was an organic farmer, and they did nothing to prevent the incidents. They seemed to just not care. Accountability. I want to talk about that for a second. We're going to ask you to make a determination that the defendants are liable for exemplary and punitive damages. And this applies when you find, if you find, by clear and convincing evidence that the defendants engaged in malice or oppression, which have been defined in the jury instructions as malice is expressed or implied as conduct which is intended to injure a person, or despicable conduct which is engaged in with a conscious disregard for the rights or safety. Okay, so it's intended to injure a person. Okay, they know flying over her farm, at least after the August 31st, 2020 incident, if there's pesticides on her property, she's going to face financial ruin. They know that. It's undeniable. It's in Mr. Lum's report. She's an organic farmer. Just stay away from her farm. If they refuse to do it. And such conduct is, it's despicable. There's no reason why they need to mess or fly anywhere near Salisha's farm. And if you engage in this kind of behavior and you do it knowingly, which the evidence shows they did, or with a conscious disregard, you're doing it in disregard for her rights. It's her home. She lives there with her kids. She makes her living there. And oppression means despicable conduct that subjects a person to cruel and unjust hardship with a conscious disregard for the rights of that person. Now, I think that the evidence shows that having months and months of work, when you're a poor person especially, get dashed in an instant for no good reason is cruel and it's unjust. And it doesn't need to happen at all. Okay, and conscious disregards just means the knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to act to avoid those consequences. Okay, so even after Ms. Odum's complaints, Mr. Lum's admonitions, friendly neighborhood recommendations, whatever you want to call them, they look like warnings to me. Jerry Frey still flies right over a property, fast and low, on August 16th. Now, I want to talk about remorse. You heard Mr. Frey testify, and he had a really emotional moment there during that testimony. And, I was moved by that. Mr. Frey's clearly an astute guy. He's that wasn't an easy moment for him, I'm sure. But then, he testified that he was not expressing sympathy for Ms. Odum at all. Not a drop. Now, all the other damages that we asked your order to compensate Ms. Odum to make her whole. And the punitive damages have a different purpose, and they're to make sure the person who engages in wrongful conduct doesn't do it again. Because you make it more expensive than it's worth to keep doing. And it's a deterrent instead of just what we usually ask for in civil cases. It's just something to put the person back in the place they would have been had the negligence or something not happened, like in a car accident. So that makes sense for car accident number one, But let's say you're in an accident, you get rear-ended, and then it happens again the next week with the same person. And then it happens again. At what point does or should the law and a jury issue a deterrent to a person such that this stops? And we think it's our position that the evidence shows that we've reached that point or beyond it. Now, we ask that you find in Ms. Odum's favor on all of her claims, and if you do, this is what the form would look like. Oh, I got two of the same one, I'm sorry. All right, this form basically asks you to determine, based on the preponderance of the evidence for each claim we've brought, whether Ms. Odum is entitled to relief under the law. And then it asks you to make a determination if she should be entitled to exemplary and punitive damages. And we ask that you find it in your favor in all claims. So thank you for your time.
Thank you, Your Honor. Do you think we could take a minute and just kind of rearrange this?
Of course.
Does this working for you? Or does that have to be plugged in?
It does need to be plugged in at times. Some
Is there a way we can kind of adjust it around a little bit so it's next to the podium?
The podium is actually it's probably the most important.
Perfect, thank you. Okay. May or may not use it, since I have hard copies here. I may or may not use it, so I'll let you know. Okay, thank you, Your Honor. I'm ready.
Proceed.
Thank you. Thank you all for this week, being here, paying attention. As I said during my opening statement, on behalf of my clients, this is important, and you would definitely learn a lot about crop dusting. I feel that has happened. And I said during my opening statement that the details would be important, especially from my client's perspective. And so I really kind of want to take a minute here to talk with you all about the details. And as Mr. Busby said, you know, what we're doing up here with this closing is it's not evidence. You know, it's not my job to get up here and try to contradict everything he just said, but really what we're trying to do is just organize what we believe the evidence is and what the facts have proved in this case. So there was one thing that I didn't quite hear, and that is, where is the proof that Miss Odum was sprayed by my clients? We have 3 separate incidents. We have my clients acknowledging flying in that area, but where's the proof that she was sprayed? You heard her on the witness stand. She said she was sprayed, she felt the spray, she felt the mist. You know, where's the proof of that? Because my clients, when you heard them, they said they didn't spray her. They didn't spray her neighborhood. They were careful to turn the spray on and off when they were in the fields. So they were spraying only while they were crop dusting in the field. So where's the proof, ladies and gentlemen? We have her testimony that she was sprayed, and we have my client's testimony who said, obviously they didn't spray her. And so when you look at the Nevada Department of Ag investigation into each of these incidents, you'll see the details. You'll see why there is no proof my clients sprayed Miss Odum. You'll see why there was no finding of any sort of violation or enforcement action taken against my clients. And so what I want to do is talk a little bit about each of the incidents. And I also want to highlight what I believe are important pieces of evidence that go along with each of these incidents. So the first one alleged by Ms. Odum is from August 31st of 2020. When you are in your deliberations and looking at evidence, that will be Vance Lum's report, exhibit number 61. That will also be the Nevada Department of Ag lab testing results from exhibit 14. And you heard from Mr. Weaver. He doesn't deny he was spraying a tank mix of insecticides a quarter mile west of her property. He did a good job of standing up there and explaining how he performed that application. The environmental conditions were correct. He was careful. He showed the manner in which he was spraying the field, the path of the crop duster. He acknowledges, making turns over the residential area, but doing so safely, carefully, making sure that he wasn't spraying when he was making these turns. And quite frankly, we have the 2 videos. We have Miss Odum's video that she took from the back porch, which shows Lynn Weaver, and we have her daughter's video from the back window of the house looking south that shows Lynn as well moving, flying back towards the field. We don't deny we were out there, but what we deny and what there is absolutely no proof of is Lynn spraying her. He didn't spray her. He didn't spray her property. And when you hear a claim that she was sprayed, and then you want to take the testimony of the expert that she hired, Dr. Miller, and you say, Dr. Miller, you've seen these lab results. You've seen that in the lilac, which is next to her back porch, the results were non-detect for both of the pesticides that Lynn was spraying that day. And then you ask Dr. Miller, for the pepper plant, where there was non-detect of 1 and 0.009 parts per million of the chlorpyrifos, is that consistent with a plants that were getting a direct spray of this tank mix of pesticides? And he said, no. Her own expert directly contradicts her testimony to you, ladies and gentlemen, that she was sprayed by my client. At most, Dr. Miller believed it's from drift and somewhere has to be a source. That was the best we had from Dr. Miller. I submit to you that there wasn't even drift from the application by my clients, and that's supported by Dale Rush's opinion, Dr. Rush, our expert. So that's a very, very important part of this, ladies and gentlemen, is there is no proof of Miss Odum's claim that she was sprayed. If you look at the second incident, which occurred on July 6th of 21. Again, Lynn Weaver was the pilot, and when you are back there for your deliberations, Exhibit 60 is Vance Lum's report for this incident. And again, his report establishes that there's no basis of any enforcement action against my clients, no proof that my clients sprayed Miss Odum. But what I want to emphasize is that, yes, there was a video that shows Mr. Weaver to the north of Miss Odum's property, and that's where he's flying from west to east, ferrying back to the airstrip, perhaps to get another load, to go out and then spray the fields out by the diversion dam. And what is extremely important is that for this July 6th of 21 timeframe, that my clients were not spraying anywhere near Miss Odum's property. They weren't spraying the Dalton Lowry field that is to the north of Miss Odum and Mr. Rakeup. I really enjoyed meeting Mr. Rakeup. I thought he was a very interesting witness, but I think he's just mistaken as to what date he saw an application taking place. And because there is absolutely no evidence that my clients were spraying in the area of Miss Odum's property on July 6th. Now, why is that important? It's important because Miss Odum claims that she was sprayed on July 6th and that her plants were soaked by my client directly spraying her. You'll see the Nevada Department of Ag complaint form that she filled out, and that is impossible. My clients were not spraying anywhere in that area. And the fact that Mr. Lum came out, he actually collected samples on a gradient pattern from where Ms. Odum claims my client was flying, and they all came back as non-detect for the herbicide glyphosate. So he did his job. It clearly established through independent proof that my client was not spraying in that area. And it 100% contradicts the testimony of Ms. Odum. Further, we observed the photos of her plants, which she said were damaged as a result of that July 6th of 21 soaking that they got from the spray. None of those plants tested positive for any herbicide. She said they were all damaged from the herbicide. I had Dr. Rush, based on his forensic agronomy and plant background, explain the other phenomenon that were causing problems with the plants. I know she brought in some photos in rebuttal about how good they looked before. Well, yeah, they could look good before, but if you stop watering them or they start to decline because of the reasons Dr. Rush described, that's what happens. So, if you attempt to follow the plaintiff, Ms. Odum's claim that my client must have been spraying on July 6th in that area to the north of her, well, let's think about what that claim would actually mean. That means my client would be spraying some either herbicide or unidentified herbicide or glyphosate on Dalton Lowry's alfalfa. Well, that would have killed the alfalfa. There's no reason we would have been spraying herbicide on Dalton Lowry's alfalfa field that's to the north of her. We're not trying to kill his alfalfa. So for her to say that she was soaked by a herbicide from us spraying in that area that day, it just doesn't make any sense. And for her to say that she had all of this damage to her plants and emotional stress because she was sprayed and the plants were soaked that day, it just doesn't add up. Mr. Busby used the example of a car accident. Imagine a car accident where somebody is claiming that they have whiplash and all this damage because you rear-ended them and the back bumper and rear panels are all falling off. And that's what they're claiming. Well, you go out there and you look and there's actually no damage to the back bumper. There's no proof that you ever hit it. I mean, sure, there's some, cracked windshield and maybe some wear and tear, a little rust or some, bald tires, which is what was happening to her plants through the natural problems associated with organic farming, but there was no smashed in rear bumper. My clients never rear-ended her if this was an auto accident. And that they were never spraying in that area to have caused her to have been exposed and for the plants to have been soaked. And when we look at the third incident, and by the way, I feel as if there's been this potential to lump all these together, like this is continually happening. This is this pattern, and day after day after day. Remember, ladies and gentlemen, these are three separate claims without proof that happened over a 1-year period. This isn't this constant bombardment from the air day after day after day. But in any event, when we talk about that August 16th of 21 incident, Mr. Frey admits he was working and spraying insecticides in that Dalton Lowry field that was to the north. But when you look at the investigation by the Nevada Department of Ag, first by Mr. Lum, there's no positive sample of any residue of anything that, of any of the malathion that's being sprayed by Mr. Frey. And then when Mr. Allen was asked, well, what about the Andersons? They took a video that shows Mr. Frey flying over the neighborhood. He collected samples from them, and theirs came back non-detect as well too. There's just no proof that Mr. Frey was spraying their neighborhood. There's no proof that they sprayed Miss Odum. There's no proof that he sprayed her property. One of the, what I think are a couple of pieces of evidence that are important from my client's perspective. When they're back in evidence, you'll have the Google map, which I think is important. That's Exhibit 62. You'll also have 62A, which was Mr. Weaver's drawing on this map. This helps the relationship of the fields to Ms. Odum's property in her neighborhood. As I said, you'll have Vance Lum's report, 61, 60, 59. You'll have the photos of Ms. Odum's plants that were not affected by any sort of herbicide, but in fact were having some natural conditions associated, commonly associated with organic farming. And you'll likewise have the videos which I've just described, none of which show my client spraying Ms. Odum or her property. But I wanted to take just another moment with you is based on the jury instructions that you just heard from the judge. When you begin your deliberations and you start plugging in the information to these instructions and look at the facts, weigh the evidence, and then apply the law as instructed, you're going to see, for example, in instruction number 6, that there's a claim of negligence, that my client breached their duty of care. We did not hear a single expert witness on behalf of Ms. Odum to come in and say the crop dusters were not flying the right way, they were flying too crazy. There was no testimony. Because there was no testimony, our position is they were not negligent. You're going to see instruction number 9 about Ms. Odum and her claim for damages. Remember, she, I believe, may have overreacted to a crop duster flying in her area because there was no proof of any exposure, there was no proof she was sprayed, and she then reported this to her organic certifying agency, CCOF, and rather than maybe pulling some samples herself, she could have hired a person just like like Dale Rush. He could have gone out there. You heard, he charges $200, $250 an hour for his work. He believes that samples that are can be tested for $250 a sample for a full panel. She could have independently investigated this on her own, but rather she just stopped. And I believe that was an overreaction. And you know, she's trying to blame my clients for that overreaction. And the irony is her own organic certifying agency, CCOF, said, oh no, you can still sell these as organic. Likewise, after this, a year later, in, you know, July of the following year, same thing. No proof that they were soaked, as she's claiming, but yet, you know, and when it got to CCOF, they said, oh yeah, no, there was no restrictions. So Odum admitted this. She abandoned her own farming, and so when it comes to awarding damages, you can't blame my clients for her decision. I think as you work through these instructions, ladies and gentlemen, you're going to end up on instruction number 17, where the plaintiff is asking to impose punitive damages against my client. And first, you're going to have to decide if you're going to make an example or punish my client. I submit to you that there is no evidence to take such action. My client's prop duster, you know, gosh, maybe that good neighbor advice that Mr. Lum gave, you know, maybe my client could have been a better steward of prop dusting. Maybe, you know, prop dusters, as we've seen from the videos, they're loud, they're flying low, they can be a little startling, they might be maneuvering around, you know, but just because of that good neighbor advice from Mr. Lum, that's not nearly enough to do something to have to punish my client for wrongful conduct. And I would submit to you that that good neighbor advice means good neighbors. And it's a two-way street. And I think overreaction by Ms. Odum, I think that she maybe needs to be tolerant. Granted, I understand her allegations that this happened 3 times over this year period. But I submit to you that when you see these instructions, there's just not any basis by clear and convincing evidence that my client was guilty of oppression or malice. There's just no despicable conduct, there's no intent to injure her, you know, there's no evidence that she was even sprayed. And I would add that in trying to award any damages, she has the burden of proof to establish by a preponderance of the evidence. Then, if she, which we submit she has not met that burden whatsoever on her claims. Further, if you were going to consider punitive damages, that has to be proven by clear and convincing evidence. Ladies and gentlemen, that is just not present in this case. So this is going to be, as a closing presentation, my one opportunity to talk with you. And after I'm done, Mr. Busby will have a chance to put on his final rebuttal summations. And so my request and my thought is just to have you realize that when you get back in your deliberations, you're going to get this verdict form. You're going to walk through each of these questions. There's 7 of them. And I submit to you that your answer to each of these first 7 questions is going to be no. And I ask that after answering no to each of those first 7 questions, then you would stop. Because you do not need to go any further on the verdict form. Really want to thank you all for this week and really paying attention to the evidence. Again, when you get back there and you're performing your deliberations, you're looking at the evidence, you're applying the law as the judge has instructed, that you would determine that there's just no liability. You would return this decision back in favor of my clients. Thank you. Thank you, Your Honor.
Ms. Busby, you may now conclude the arguments. Do you want that reoriented back out well?
Your Honor, I have nothing further to say. Thank you.
Okay.
So, our jury panel, as it sits now, consists of 9 people. The civil jury consists of 8 jurors. And so, and at the beginning, the court and the council knows who has been selected as alternate jurors. In this case, it was the last 2 that were selected. We excused 1 juror in the process. And so you are our alternate juror. And so you won't participate in deliberations at this time. We'll ask you to stay here for a minute. We'll excuse you after the jury retires to deliberate. We'll express our gratitude for you and give you some further instructions at that time. The jury may take with them to the jury room all papers and other items which have been received as evidence in this case, the written instructions given by the court, and all notes taken by the members of the jury during trial. The jury may request to avail of further information or instruction. The clerk will now swear the officer to take charge of the jury.
Do you solemnly swear that you will conduct this jury to some private and convenient place for their deliberation, there keep them together, and that you will suffer no person in any manner to speak or communicate with them, nor do so yourself, unless by order of the court, except to ask them if they have agreed upon a verdict, and when they have agreed, that you will conduct them into court unless otherwise ordered by the court, so help you God?
Yes.
Now excuse the jury proper, and we'll get the information, the instructions to you. We're back on the record on case number 21-1038, Odum v. Frey. Record should reflect the presence of the parties, all counsel, all court personnel. The jury has retired to the jury room. We have our lone remaining alternate juror here. We'll now excuse you. I'd like you to leave your, if you'd like to know what the verdict is, if you leave your cell phone number with the court clerks at the window, we can call and inform you. But while I'm excusing you for now, I'm going to give you the same admonishment I've given you at the end of every day. If there, I don't anticipate this, but in the law, we're trained to kind of worry about the worst case. If something were to happen and the juror had to be excused, then maybe call you, at which point you would join and maybe begin deliberations anew. So I'm going to admonish you not to converse among yourself or with anyone else on any subject connected with the trial. Do not communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Do not read, watch, or listen to any news or media accounts or commentary about the case. Do not do any research, such as consulting dictionaries, using the internet, or using reference materials. Do not make any investigation, test a theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. Additionally, it is your duty not to form and express an opinion on any subject connected with this case until it is finally if you were to ask to rejoin the jury, it would be submitted to you for a decision. And so I'll excuse you to go home. We'll leave your contact information. What I fully expect is that we won't recall you, but once a verdict is reached, the court staff will contact you, and at that point you can talk about the case to anyone you want or not talk about it. Does that make sense?
Yeah.
You are excused from jury duty for the remainder of this year and all of next year. You may get summons in because some people like to serve, but all you have to do is contact the jury commissioner, tell her that you've served on this jury and that you would like to be excused, and if you want to be excused, you'll be excused for the remainder of that time. I want to thank you for your willingness to take a week out of your life to participate in this process. It inspires me again and again every time I do this, the willingness of so many members of our community to freely give of their time to participate in what I think is one of the most wondrous processes that exists within our country. And so I thank you for that. And so, counsel, is there anything next? Excuse me, Steve.
Yes, thank you, Your Honor.
Sure. Thank you. If you'll just go to the window and let me know. Go back on the record on case number 21-1038, Odum v. Frey. Where parties and counsel and all court personnel are present in the courtroom. We're outside the presence of the jury. The bailiff has informed the court that we received a verdict, so I'd like to invite the bailiff to have the jury come to the jury box. Go back on the record on case 21-1038, Odum v. Frey. Parties, counsel, all court personnel, and now the jury is present in the courtroom. Will counsel stipulate to the correct seating of the jury?
So stipulated, Your Honor?
Yes, Your Honor.
Ladies and gentlemen of the jury, who have you selected as your foreperson?
That would be, Your Honor.
Has the jury reached a verdict?
We have, Your Honor.
Would you hand the verdict forms to the bailiff? The clerk will now read the verdict.
We, the jury, in the above entitled action, find as follows. Number 1, do you find by the preponderance of the evidence that the defendants were negligent? No. Number 2, do you find by the preponderance of the evidence that the defendants were negligent per se? No. Number 3, do you find by the preponderance of the evidence that the defendants assaulted Salisha Odum? No. Number 4, do you find by the preponderance of the evidence that the defendants battered Salisha Odum? No. Number 5, do you find by the preponderance of the evidence that the defendants trespassed on Salisha Odum's property? No. Number 6, do you find by the preponderance of the evidence that the defendants created a nuisance on Salisha Odum's property? No. Number 7, do you find by the preponderance of the evidence that the defendants converted Salisha Odum's personal property? No. Dated this 9th day of June, 2023, David Caperton, foreperson.
Thank you. Before the verdict is recorded, does either party request that the jury be polled?
We so request, Your Honor.
No, Your Honor.
The clerk, if you'll please poll the jury and go ahead.
Okay. Your Honor, would you like me to item by item?
Do you want item by item?
No, Your Honor.
Okay.
Juror number 1, was this your verdict?
Yes.
Juror number 3, was this your verdict?
Yes.
Juror number 4, was this your verdict?
Yes.
Juror number 5, was this your verdict?
Yes.
Juror number 6, was this your verdict?
Yes.
Juror number 7, was this your verdict?
Yes.
Juror number 8, was this your verdict?
Yes.
And juror number 9, was this your verdict?
Yes.
Mr. Busby, is that sufficient for?
Yes, Your Honor.
Okay. The clerk will now record the verdict of the jury in the minutes of the court. Ladies and gentlemen of the jury, I'd like to just take a minute and thank you once again. I have been impressed throughout this week with your patience. We've had very, very good counsel who presented this case, but we've had, for necessity, have to take some breaks, and you've been very patient with us. And I thank you for that. Also thank you for the attention that you paid during this case, and for your willingness to sacrifice and be a part of what is a very, very important part of our system. I hope it's been a good experience for you. If it hasn't, I'd like to hear about it. If it has, I'd also like to hear about it at some point because we'd like to know what ways that we can improve, because we realize how much we're asking of our citizens when we ask them to come in. You will be excused from jury duty for the remainder of this year and all of next year if you want. Now, if you get summons in and you want to serve, you're welcome to serve again. But if you get a summons and you don't want to serve, all you have to do is contact the jury commissioner and they will excuse you. Tell them that you served on a jury and you'll be excused. As we leave today, either afterwards, if anyone lingers, frequently counsel will like to ask questions. You're under no obligation to talk to anyone, but you're also free now to talk to anyone you want. You can go home and talk to your families. You can look on the internet. You can do all the things I told you not to do. You're free now to do. If counsel calls you in the future, you're welcome, or a representative, you're welcome to talk to them, but you're under no obligation. I can tell you based on my experience with this counsel, I fully expect that they would respect whatever your decision was, but on occasion, someone doesn't want to talk and there's some persistence, and so you let me know and we'll make sure that if you don't want to be contacted, we'll also make sure that happens. Does that make sense? Just from the bottom of my heart, I want to thank you. This is one of the most impressive things I do when I deal with the citizens of our community who come in here, and so I just want to thank you for that. We'll now excuse the jury.
Yes, Your Honor.
Mr. Leath, if you'll prepare a judgment on the verdict of the jury and submit it to the clerk of the court within 14 days.
Yes, Your Honor.
And the clerk is authorized to execute that judgment in accordance with the jury's verdict. Are there anything else the plaintiff needs to put on the record?
Not this time, Your Honor.
Anything else from the defense?
No, Your Honor, thank you.
And I want to just thank both counsel. You were all very well prepared, very respectful of each other, but zealous advocates, but true. This is what our profession is all about, so I want to thank you. Also want to thank Ms. Odum and Mr. Frey for your participation, and know that coming here to see me in this context is never fun, and so I appreciate both of you, and I wish everyone the best going forward.
Thank
We'll
you.
be in recess.
Thank you, Your Honor.
Thank you.